Hello everyone, this is Mr. Laubach. Hope you're having a great day so far. In this video, we are going to go over one of the more cherished rights of American citizens, and that is the right to privacy in the context of the Fourth Amendment. The Fourth Amendment was designed to prevent the use of a writ of assistance or a blanket search warrant by the government. Now, this grew out of colonial frustration towards the British that the colonists had because they felt the British law enforcement was using a writ of assistance too haphazardly to go and search people's private property. It should also be noted that each state's constitution, so Pennsylvania, contains a similar provision. So not only is this to be followed by the federal government, the Bill of Rights, but to make certain it was extended to everybody, it has also been placed in individual state constitutions as well. Now let's take a close look at the verbiage or the wording of the Fourth Amendment. The right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that is the Fourth Amendment itself. Now, the Fourth Amendment is very wordy, and there's a lot to dissect from what we just read. So let's take a closer look. The Fourth Amendment is triggered when there is a search by the government. The government usually means the police or law enforcement, but not necessarily always. The basic rules laid out in the Fourth Amendment is that law enforcement does not have unlimited rights to search for evidence or to seize either evidence or person. So there is a limit on the government's power to search someone or seize property. It is very important that we are referring to the government here. We are not necessarily talking about a nosy neighbor or a family member. On its basic level, it is about when the government trespasses on someone's property or looks to obtain or search a person. Now, in some areas, there is a reasonable expectation of privacy, like in a bathroom or in your home. There is not a reasonable expectation of privacy when you are walking down the street or are in public. Now, what exactly does it mean to be seized? An item is seized when a person takes it. A person is seized or taken into custody when they are detained by law enforcement. Now, for a search or a seizure to be constitutional, it must be reasonable, and that's what we will talk about moving forward here. What constitutes a reasonable search or seizure? Now for a warrant. A warrant must be obtained to search property or seize property or detain a person. Now, in order for a warrant to be obtained, there must be probable cause issued by a neutral and detached magistrate or judge and described with particularity, meaning specifics. So what is probable cause? Probable cause means a fair probability and a logical belief that a crime has been, is being, or will be committed based on objective facts and circumstances. As you can imagine, this definition opens the concept of probable cause to a lot of scrutiny. In the spirit of fairness, the judge issuing the warrant cannot be part of the investigation or otherwise connected to the person or the item in question, particularly describing the place to be searched, the person or things to be seized. The reason for this is to prevent the government and the police from randomly searching people's property or person. Think back to our writ of assistance in colonial days. Now, this is very important. As you can see, the Fourth Amendment can be very ambiguous. So let's talk about what is known as exceptions. The police can search and seize an item or a person if certain criteria applies. This is referred to as an exception. One exception is consent. If a police officer gets consent of the person being searched or the owner of the item being searched, no warrant is necessary. This permission must be given voluntarily. Police cannot coerce the individual to giving consent. The plain view rule. Plain view is another exception. If it is obvious to see something illegal and the police officer is at the vantage point in a legal way, that stuff can be seized without a warrant. The incriminating characteristics of the item must be very apparent to the police officer. So that is an important criteria. SITLA, or S-I-T-L-A, is the third exception. This is an acronym for Search Incident to Lawful Arrest. This allows a police officer to search a person that is being arrested and search the immediate area or the property in which the person is being arrested on or near. The courts have ruled that a big reason for this is to protect the safety of police officers and to preserve evidence. Now for the vehicle exception. The reason for this exception is because how mobile a vehicle is, and if an officer went to get a warrant, the vehicle could easily and lawfully be moved or hidden from where the officer encountered it. Terry stop and search. This comes from the Terry versus Ohio Supreme Court ruling. An officer does not need probable cause. They only need reasonable suspicion to search a person or an item. This has to be based on fact and not just a hunch of a police officer. As you can imagine, there are significant gray areas regarding this. Now let's take a look at what this Terry stop and search might look like. So as you can see on the image here on the left, reasonable suspicion that a criminal activity is afoot. Brief investigation, stop and ask questions. So this officer thinks that this person might be involved or witnessed a crime. So they are allowed to stop and talk to them. Now, if the officer has a reasonable belief that the person is armed, they are allowed to pat down outer clothing for weapons only. And this oftentimes is done to protect the safety of the officer. Now, the arrest, probable cause to arrest. Full search of the person and the area within his immediate control has led to enough evidence for an arrest or the person to be detained. If a police officer has a reasonable suspicion, they can stop and briefly search and question a person. Keep in mind that if an officer of the law feels that they or the people in the area or the person themselves is in danger, this would be considered reasonable suspicion enough. So as you can see in this graphic, the police officer says you match the description of a bank robber. What is in the bag? That would be lawful in that instance. As you can see in this image, the police officer says there's an armed robber on the loose. For my safety, I need to pat you down. So this again would be lawful. If the reasonable suspicion is dispelled by the brief search, the search must end immediately and the person must be allowed to go. So what happens if the government violates the Fourth Amendment? In other words, an arrest or evidence is obtained when there is no warrant or an exception does not apply. This means an unconstitutional search or seizure occurred. This is when the exclusionary rule kicks in, which states illegally obtained evidence cannot be used against the person whose rights were violated. So it could not be used as evidence or in a trial against them. As you can imagine, this incentivizes police officers to gather evidence properly and constitutionally. Let's take a look at this flow chart. So let's pretend that an incident occurred. Is there a warrant? If the answer is yes, and this is based on probable cause, issued by a neutral and detached magistrate or judge, and described with particularity. If the answer is yes, the Fourth Amendment reasonableness has been satisfied, this evidence can be used. Let's say there is not a warrant. Does an exception apply? So we talked about our 4 exceptions earlier. If the answer is yes, then the Fourth Amendment reasonableness applies and evidence can be used. If there is not an exception and there's not a warrant and the search continues, the Fourth Amendment rights of an individual have been violated and this evidence would be excluded. This is also known as the exclusionary rule. So I know there's a lot of information, and if you have any questions, please let me know. I hope this makes sense and have a great remainder of your day.